flip side of our press program is on the Shield Law. Our first speaker is Ed Hines, an honors graduate from the University of Wisconsin. He was the editor of the Waverly newspapers, joined the Des Moines Register and Tribune in 1963 as a reporter with special emphasis on agriculture, business, and conservation. In 1967, he was cited by the American Political Science Association for distinguished reporting of governmental affairs. He was named managing editor of the Des Moines Register and Tribune in 1969. Ed?
Thank you, John. On top of every editor's desk, there's usually an inbox and an outbox. In the few years that I've been managing editor of the Register and Tribune, I've changed my mind about how to handle the flow of material in and out of those boxes. When I was younger and newer on the job, I had a policy of trying to get everything out of the inbox and acted on and back into the outbox all in the same day, so that there would be a constant flow of work. As time went on, I got a little smarter, because I finally realized that this do-it-now attitude had really limited my chances or my choices as far as a manager was concerned. I was limited to yes or no. It left out all the options which said maybe, if, or what'll it look like tomorrow. Now, I still have two boxes on my desk, an inbox and an outbox, but I'll admit, quite frankly, that some of the things in my inbox at the bottom have been there for quite some time. Last fall, I attended a management seminar in Boston, chaired by the psychiatrist who set up the Menninger Industrial Psychology program. One of the management principles that he stressed was this one of not doing everything immediately. This is a very definite managerial choice, and often can be the best decision possible. I can't help but think that such a decision might also be the best one to use right now when it comes to the Shield Law debate these days. When you come right down to it, the wording of the U.S. Constitution concerning freedom of press is as broad as the press will ever get. Sure, we have had some jailings of newsmen in some states, and there have been some recent U.S. Supreme Court decisions which leave something to be desired, at least from our standpoint. But the chances of getting legislation that gives newsmen an absolute shield are dim, and anything that seeks to define the present wording of the Constitution more precisely could pose a long-term threat to press freedom. Now, before we get too far into the discussion, I want to say that my admonition against any hasty shield legislation does not mean that I'm in favor of going to jail. And I have reason to believe that my wife and my children are not in favor of that either, well, at least today. What I am saying is that every time the press goes hand in hand to politicians to get special legislative treatment, it is endangering the balance under which our government works. In my opinion, we have weakened ourselves in the past by asking for and getting special antitrust consideration under the Failing Newspaper Act, and the exceptions written into the so-called open meetings law in Iowa oftentimes take more precedent than the main section of that law. To refresh our memories, the First Amendment of the U.S. Constitution says, Congress shall make no laws respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble and to petition the government for redress of grievances. The chances of any current legislation coming out of Congress or the Iowa legislature that is more of an absolute shield than that is very dim, in my opinion. What we would get, if a law passed, would be something less broad than the Constitution, and quite possibly something which allows the government to define a newsman. I don't have any doubts that regardless of what you think about it, the Register and Tribune could qualify, could meet any definition of the press that the legislature or Congress could set up. But that doesn't mean that we want that. The diversity of opinion that the Constitution envisions when it avoids any strict definition of the press is part of the strength of our system. Certainly, I would be nuts to advocate that only the established press should be allowed special privileges of a shield. I don't want to be beholden to any governmental unit for a definition of us as a member of the press. I also don't want for the press any special privileges that aren't given to all citizens. You can see that the First Amendment is really talking about the exercise of religion, speech, press, and assembly for all citizens, not merely for some groups of citizens that happen to meet some governmentally defined rules as to being a member of the press or a religion. One of my other reasons for seeing more dangers in the Shield Law than protection is that I'm convinced that a newsman very seldom needs the opportunity to hide behind such protection to protect confidential sources. I can use as my source to back up that statement the chief of our Washington Bureau, Clark Molinoff. Whatever your opinions of Molinoff are, I don't think anyone will accuse him of being shy when it comes to investigative reporting. He said in a piece published in our papers a few weeks ago, quote, "I have been working as an investigative reporter for more than 30 years, and that experience has involved a broad and various use of confidential sources. It has involved exposure of scandals from the Polk County Courthouse in Iowa to the White House and essentially every type of city, county, state, and federal agency. I have always protected my confidential sources, and in only a few instances have I ever been faced with the choice of deciding whether to reveal the source or risk a contempt citation. The crisis never materialized." One of the main reasons that this sort of a crisis does not materialize is that the adequate reporter very seldom has to base any story exclusively on confidential sources. Confidential sources most often are only the opening tip for an investigative reporter to get started on a story. The tipster, in effect, only shows the reporter where to start looking. The reporter himself gathers the corroborating evidence and bases his final news story on documented evidence and not on anonymous tipsters. The investigative report, frankly, that doesn't have that sort of documentation is suspect, and I would be the first to suspect it. Another reason for being somewhat reluctant to be stampeded into settling for any sort of shield law that is in Iowa, the reason for not being wanted to be stampeded is that in Iowa at least, we have had and continue to have a stability of thought on all sides. The legal profession, both the lawyers and the judges, have been reluctant to seek any rash of subpoenas against newsmen. The press has been reluctant to rush into print with unsubstantiated stories based only on confidential sources. And the politicians have been reluctant to press the issue of seeking to define the press and put on strictures. This balance of understanding from various elements of our society has always been one of the strong points of life in Iowa. Once again, we are seeing the benefit of that stability. I don't think that the lawyers, judges, politicians want to be in a position of seeking more restrictive definitions of the press. By the same token, I don't think the press is eager to have laws which would make its members something above other citizens of the country. This ability of the various elements of our society to work together to make the democracy function is an element in this entire controversy which has been overlooked. Fortunately, we have had the type of climate in Iowa that makes this give and take work very well. And I don't think we've had to sacrifice any vigor on the part of either the press, the legal profession, or the government. Finally, another reason for wanting to see if we can't work within the general framework of the Constitution rather than go to a specific shield law is the doubt that anyone, especially the press, will do better with another try at lawmaking. I use the state's open meeting law as an example. The law flatly states in the first paragraph that all meetings of public agencies are to be, quote, open to the public at all times. unquote. But then we get to the third paragraph, and this is where the exceptions start creeping in. We find that the meetings are open except where personalities are being discussed, except where real estate purchases are being considered, and finally, except for some other exceptional reason so compelling as to override the general public policy in favor of public meetings. Quite understandably, some governmental units have found quite a few reasons for having exceptions to the rule. There would seem to be no chance that we would get a shield law without exceptions. You can understand our skepticism, therefore, towards the exceptions when you know how tough it has been when it has been applied to the open meetings law. So in conclusion, I would have to admit that when it comes to pressures to do something about a shield law, I'm frankly dragging my feet. I'm convinced that the present constitutional definition of the press is better than anything we will get if shield legislation were passed at either the state or the federal level. Thank you.
Thank you, Ed. Our next speaker will be State Representative Arthur Small. He received a BA degree from Bowdoin College and an MA from the University of Iowa. Served 3 years with the Army Security Agency as an electronic specialist, which sounds somewhat dubious for civil libertarians. Despite that, he was a legislative assistant to former Congressman John Schmidhauser and is a founding member of the Iowa Democratic Conference. He was elected state representative in 1970 and re-elected last year. As a sophomore legislator, he was named assistant minority leader. He was one of the sponsors of an Iowa shield law bill, but I gather from talking with him more recently that he has some ambivalence about the desirability of a shield law. He's going to be sort of half a devil's advocate in this panel, in that he's going to emphasize that part of his ambivalence which favors a shield law. Art?
Thank you. I'd first like to perhaps respond to some of the comments that were just made previously. The first thing I'd like to stress is that the so-called special treatment that one would seek under a shield law is not for the press. That point should be made clear. It's for the public. It's to ensure that the public continues to have access to the information which is needed in a free society. On the second point, that was sort of intimated that a proper shield law would require one to define such things as newspapers and press, I think that can be avoided. I think you can avoid it in the same by allowing the courts to make those decisions. You can use these words, but the court, in interpreting the First Amendment, has to make these decisions anyway. The third point, just a few things I sort of checked as I was listening to Ed. The third point, he referred to Clark Mollenhoff's 30 years experience. And as a consequence of that 30 years experience, Clark Mollenhoff sees no need for the shield law. And that's probably true, because in the past 30 years, we haven't had the same situation as we are now having. I think that point should be emphasized. We are in a new situation today, and that is why this controversy has come up, because of the 5-4 rulings by the Supreme Court with respect to Caldwell and with respect to some other people. Now, he has also mentioned the reluctance of the politicians and the reluctance of the county prosecutors and so forth in this state to go after the press, or go after them in the sense of requiring them to deliver testimony in grand juries and the like. That's true, and we have been fortunate. However, in the past couple years across the country, what we are seeing is a changing use of the grand jury system. The grand juries are being used now to do the type of investigative work that should more properly be done by the police agencies. And that is the reason, one of the main reasons we're into this dilemma, that along with the Supreme Court decisions. To refer you to some comments by Charles Perklin, who is president of the Newspaper Guild of the AFL-CIO. He pointed out in testimony in a congressional subcommittee which was investigating the question of should the Congress go into a shield law, he pointed out that the Newspaper Guild back in 1934, when they adopted their code of ethics, which state that they would refuse to reveal confidence or disclose sources of confidential information in court or before other judicial or investigating bodies. When they did that back in 1934, there wasn't the same type of climate of opinion that you have today. There wasn't the same usage of the grand juries. And it wasn't until 1969, or the latter part of the 60s and the early 70s, in the past couple of years, that this veritable flood of demands that newspapers disclose their information, materials, and sources, not only to law enforcement bodies but other defendants, has come about. To give you some figures, in the past, quoting from him, in the first 2.5 years of the Nixon administration, in fact, 30 subpoenas were served on the Chicago Sun-Times and the Daily News alone, 2/3 of them on behalf of the government. One reporter, Dwayne Hall of the Sun-Times, was served in 11 separate proceedings within 18 months. During the same 30 months, 124 subpoenas were served on NBC and CBS and their wholly owned stations, some by federal and state prosecutors, others by defendants. So I want to point out, first of all, that we wouldn't be here talking about this had we not had significant changes in the use of grand juries and in the attitudes of primarily the Nixon court. Now, to go on to a couple other points that I think should be brought out, that it was mentioned earlier that I think it's Lowell Ford or somebody else who said that the press is an industry. We ought to accept that fact. Well, it is, but I think if you just think of the press as an industry, you're on a very dangerous ground, because obviously the Constitution of the United States sets the press apart as being something other than just an industry. It does grant the press a special status, and obviously the Founding Fathers were expecting that the press would function in a way other than just as an industry to sell some sort of soap and underarm deodorant and the rest of it. They have a different responsibility, and they are treated specially. It's unfortunate that the Supreme Court didn't recognize this or didn't continue the tradition. We have to react, though, now, I feel, to the individual situation. Not only does the press have special consideration as regards the First Amendment, and let me reiterate, it isn't the press that has special consideration, it's the public that has special consideration. The public's need to know, the public's right to have a free flow of information. The law also, I might point out, recognizes other privileges, though. We have lawyer-client privileges, priest confessional privilege, husband-wife informers. And the question about the Shield Law is whether or not this a privilege should be granted to reporters and the press in their confidential relations with those who provide them information which is vitally necessary for the maintenance of a free society. Now the question is, should we have state laws? Well, first let me point out that 18 states do have shield laws. Some of them go back, the Pennsylvania shield law goes back into 1937. Admittedly, many of these shield laws are not drafted perhaps the way we would hope they would be, because they were drafted in a climate of opinion, though, I might stress again, which was different then than it is today. I think I would hope that I would share its feelings that if we do have a shield law at the state, that we do have what you call a pure shield law with not umpteen different exceptions which undercut it. But the essential argument for the shield law, I think, is pointed out in a recent Supreme Court of Pennsylvania decision, or 1963, a little while ago, which upheld the refusal by executives of the Philadelphia Evening Bulletin to disclose information and sources pertaining to stories about alleged municipal corruption. And the court said then that it is vitally important that this public shield against governmental inefficiency, corruption, and crime be preserved against piercing and erosion. The district attorney points out that such a construction of non-disclosure of sources will enable newsmen to conceal or cover up crimes. This is correct. However, we are convinced that the public welfare will be benefited more extensively and to a far greater degree by protection of all sources of disclosure of crime, conspiracy, and corruption than it would be by the occasional disclosure of the sources of newspaper information concerning a crime. It's for that reason they said the Shield Act of 1937, the Pennsylvania Shield Act, is a wise and salutary declaration of public policies whose spiritual father is the revered constitutionally ordained freedom of the press. Now, it would be a very wonderful world if we didn't need the Shield Law. But the fact of the matter is that the Supreme Court, in their decision, and that Supreme Court isn't going to get any better, it's going to get worse. The Supreme Court has thrust upon us, I think, a new responsibility, which they themselves outlined when they said that in their decision, the majority decision, White's decision, that this journalist privilege could best be solved by Congress and by state legislatures. I think we have to, admittedly, a difficult task, but I think we have to begin to address ourselves to it, and I think we should pass a Shield Law in the state.
If that's being half a devil, I wonder what you do when you really believe in something. Our next panelist is Jerry Nelson, a student at the University of Missouri with BA and MA degrees from the University of Washington, a reporter for a number of Pacific Northwest newspapers, including the Seattle Post, Intelligencer, and Times. 14 years of experience in the newspaper business, and more recently, assistant professor in the Journalism and Mass Communications Department at Iowa State, where he teaches basic reporting and writing. Jerry.
You know, I better correct something. A graduate student at the University of Minnesota, just so any alumni from there won't take offense. Maybe they will after I get through. I was surprised as I listened to Ed Hines to find out that great minds run together in the same channels. I didn't know how he had managed to copy me without hearing what I had to say first. Ordinarily in academia, we don't have to take solid positions on questions of this kind. So when I was asked to appear on the panel, I finally decided, well, I'm going to come down one way or the other. And I have come down on the side opposing Shield Law legislation. And this is really an unhappy situation in a lot of ways when you discover who you're in bed with. For example, Friday night I discovered I was in bed with Agnew. If I'm not careful, I'm going to lose my credentials as a neighborhood radical. At any rate, if I read the Register's account correctly, and if it's correct, as I suspect it is, despite Agnew's attempt to erode my confidence in it and all other aspects of the press, I do agree with what he said on Shields there. He said that the question confronting us is a difficult one, and certainly the two gentlemen who preceded me have made this clear. And he said further and more specifically that, quotes, a person accused of misdoing must not be prevented an adequate defense because he cannot locate his tormentors, end of quote. Now, assuming that Agnew meant what he said when he said that, perhaps this is a tremendous assumption, and assuming also that he might go along with the idea of reporter privilege at all, then the kind of privilege that I think he would advocate I can put thoughts in his mind, would have to be qualified. That is, it'd have to be qualified to the extent that a person accused of crime would be able to penetrate the reporter's shield. That is, there would then be exceptions to the kinds of things which journalists do, where they couldn't claim the protection of a shield law. The minute they were unable to do this, and the minute that they were asked to divest themselves of this protection, who would decide? Well, quite clearly the courts would. And as a journalist, it seems to me that judicial control and judicial decision about this kind of thing is no less repulsive than executive or legislative control on press freedom. In my opinion, any short-run benefits we might derive from qualified shield laws, that is, ones which make exception, I'm perfectly in agreement with Hines on this, would vastly be outweighed by the long-term erosion of First Amendment freedom that might occur, and I would think that the probability is great that it would. Okay, if qualified shield laws then are not acceptable, how about unqualified reporter privilege? I think that the principal arguments for this fall into roughly 4 categories. First, we are told that unqualified laws would be an aid to First Amendment freedom. I think the kind of a position that was expressed by Small, that the public would, their right to know would be enhanced by this. That's one kind of argument. Second, such laws would protect the press in conflict with government, and this is another thing that many of us perceive as happening today. We're in conflict with the courts, we're in conflict with the executive, and so on. Third, such laws would help the newsmen do a more complete reporting job. They begin to get insulting as you go further down the line. Fourth, SHIELD would help the public find out more about affairs of concern to it, which is rather a repetition of the second one. Okay, if we tie together the third and fourth reasons I've suggested here for an unqualified shield law, it seems to me perfectly reasonable to argue that if the newsman does a more complete job, then the public is likely to find out more about those things of concern to it. This seems perfectly reasonable. The thing that doesn't seem reasonable is why a shield law is required for the profession to do a more complete job. I don't think, and apparently Hines reinforced the notion earlier on, that Molinoff has slacked off one jot or tittle. Furthermore, I suspect that Flansburgh, as we consider our friends in the legislature, has not slacked off in the kind of job he does. Now, to say that the press corps, that is the professional journalists, are doing a complete job still doesn't get to the question, I suppose, of public confidence. But I'm content to make the assumption that in many cases, if not most, professional journalists are doing their job. Okay. What the shield law then does, it seems to me, to strip it of all of its niceties and complexities, is simply make the job of the journalist easier. And it seems to me that the principal thrust of many of the arguments that are made for shield law is simply that. It's an argument from difficulty. It's going to make our job easier to do. It says nothing about the rights of other persons we might violate in the doing of that job. And again, I find myself in agreement with Hines that in some cases, particularly when we consider Fifth and Sixth Amendment rights, where I don't think our rights as journalists ought to supersede or go before our rights as citizens. Okay, to take the second reason I suggested, that is that shield laws would protect the press from, in its conflict with government, it seems to me we're muddying the water of a rather important theory of the press here, if we buy that argument. That is, one view of the press's role is that of adversary to government. By definition, then, it's in conflict. Okay, if we shield it, we're simply making that job easier. Coming back to this idea of the shield law largely being used to prevent the newsman from having a great deal of difficulty. That is, he walks in and picks up the stuff with no sweat, which may be an oversimplification of this position. Finally, how do we aid First Amendment freedoms by passing shield laws? I think here again we're asking that our job as professional journalists be made easier. If we look at the First Amendment and the way it was written, it says that Congress shall make